Hello again. I thought I'd kind of pick up where I sort of left off in a previous video. And I had some comments from some people that have started watching this playlist um, about the Admiralty Maritime jurisdiction of law. And I thought I would uh, mention a few things about that. And talk about some other stuff as well. It's all related. It's just how is it related? This first document that I pulled up, this is Common Law Roots and Fruits. Um, this is actually by Reverend Professor Dr. Francis Nigel Lee. This is from his dissertation to get his Juris Doctorate degree or something like that, I think. Yeah, doctoral dissertation submitted in partial fulfillment of the requirements for the degree of Doctor of Common Law by Nigel Francis Lee, Southern Rutherford School of Law, Florida, blah, blah, blah. And I wasn't able, this doesn't allow me to highlight, so you'll have to give me a minute. But there's some very interesting things here that I would try to point out. This was a kind of an interesting quote. Let me see if I can make that a little bigger. This is a quote from Sir. I think this is Blackstone saying this in quotes. Sir William Blackstone from the Commentaries on the Laws of England. Sir Edward Coke. I know it looks like Coke, but it's pronounced Cook. Suppose the common law of England, alias Britain, and Scotland, alias Scotic Ireland, to have been originally the same old common law of both kingdoms. God, meaning the Creator, when he created matter and endued it with a principle of mobility, established certain rules for the perpetual direction of that motion. So when he created man and endued man with free will to conduct himself in all parts of life, he laid down certain immutable laws of human nature whereby that free will is in some degree regulated and restrained, and gave him also the faculty of reason to discover and purport those laws. Now the reason I'm starting here is I think it's important that people understand that there are only two sources of law. It's either this creator, and all the jurists will legal textbooks everywhere will agree with this. Whatever you want to call this creator, most of us who are of the Judeo-Christian and even the Abrahamic monotheistic religious backgrounds, all cousins, so if you will, the Ishmaelites, the Israelites, and so on, and everybody that's been grafted into that belief system, call that God, the creator of the universe. In the Abrahamic or biblical tradition, we see Yahweh or Yahuwah, Yahweh, Jehovah, as the name for that mighty one. And that's what we're referring to here because this is, you'll see this goes back, they're claiming that. And I mentioned, I think I kind of covered this from another book too that I have on the shelf over here. Let me see if I can find this because this was kind of shorter. Here we go. Let me blow that up too. Let's see if we can make that larger. Real quick to make it easier for you to see on the screen without getting too close and make things a little fuzzy. There we go. All right, so let me get that highlight out of there. Okay, this is from a book called Missing Links Discovered in Assyrian Tablets by E. Raymond Capp. It comes from chapter 12, page 199. It says there, and it's referring to the United Kingdom and the United States of America, their legal systems and constitutions are built upon the same common law. which had its origins in the law of Moses, the law of the Lord, which all capitals, that's that name, Yahweh, the Tetragrammaton. Hence the fame of American and British justice throughout the world. We should point out that these laws formed a part of our culture long before the Christian era. These facts give us added proof, forming another link in the chain of evidence connecting us with ancient Israel. The common law began in England as far back as 1100 BC when it was codified by Brutus, Brute of Troy. Brutus was a great-grandson of Aeneas, a descendant of Judah Zerah, and you can refer to Genesis chapter 38, verses 27 through 30 for that reference for Judah Zerah. The law was again codified by Malmudius about 500 BC. King Alfred the Great again codified it. Alfred, the renowned Saxon lawgiver and administrator during the Saxon period, places the divine origin of the law in the forefront. The following is taken from Alfred the Great, which proclaims the law of Moses as the basis of Anglo-Saxon administration. The king's laws. Coming then to this task, with this in view, we find Alfred's Code, or Alfred's Dooms, as they are called, starting with an almost literal transcript of the Decalogue, aka the Ten Commandments. The only variations of any moment are that the second commandment is omitted from its right place and stands as the 10th. Immediately after the Ten Commandments come selections from the Mosaic Code, chiefly from the 21st, 22nd, and 23rd chapters of Exodus, very lightly modified. Now let me go back to this other document that I was reading from, and we can see he's also confirming it. So here's a second witness, BC Roots and AD Fruits of British Common Law. Dunwallo Malmudius, he spelled it a little differently than I did in that, or that other book did. When I typed that up, I was just copying from that other book. Around 510 BC, excelling all the kings of Britain in comeliness and courage, he fashioned for himself a crown of gold. This king established among the Britons the laws that were called the Mulmudetine laws, which even today are celebrated amongst the English. He ordained that the temples of God and the cities should enjoy such privileges as that, in case any runaway or guilty man should take refuge therein, he should depart thence. And that's referring to the Mosaic Code, referring to the what were called cities of refuge. And we find that in the book of Numbers, chapter 35, as one reference for the cities of refuge. Moreover, he ordained that the roads should be held inviolable. In his days, the knife of the cutthroat was blunted, and the cruelties of the robber ceased in the land. After Dunwallo's death, his son Belin, from around BC 455, was the undisputed master of the island from sea to sea. He confirmed the laws which his father had ordained and commanded that even the steadfast justice should be done throughout the realm. Especially careful was he to proclaim that the cities and the highways should have the same place that Dunwallo had established. He dedicated them with all honor and dignity and proclaimed it as of his common law, that condign punishment should be inflicted on any that do violence. So again, that's some of the penalties in the Mosaic Code revolve around a principle of value for value. We see that in eye for eye, tooth for tooth, wound for wound, stripe for stripe, life for life, limb for limb, etc. Value for value. There is no major, punitive action in the Mosaic Code for extravagant tort awards, like the lady with the McDonald's, burned her leg, probably, maybe $100 worth of value to heal herself, with a doctor bill or something, and then she gets hundreds of thousands of dollars sort of thing. So there's a few more things here I wanted to go through. This is a very good read if you find this on the internet. Again, let me pull this up for you. This is Common Law Roots and Fruits by the Reverend Professor Dr. Francis Nigel Lee. And I'm going to scroll down here a little bit. See if I can. I wasn't able to highlight, so it's kind of hard for me to find things real quick in this. But let me see what I can do here. Bear with me. But when we get to the section with kind of dealing with the United States, oh, here we go. I saw Richard Henry Lee's name and Francis Lightfoot Lee. Okay, I'm going to start here where it says Thus, Francis Lightfoot Lee of Westmoreland County in Virginia signed the Westmoreland Declaration against the 1765 British Stamp Act. That act of the British Parliament in London proposed to levy taxes on various American colonial documents, such as all newspapers, advertisements, and legal documents, etc. However, such American taxes should not have been levied by British representatives of British constituencies assembled in Britain, but only by representatives of the American colonies, and indeed only when assembled precisely in their own existing colonial parliaments in America. Francis Lightfoot Lee of Virginia's Westmoreland County objected to the British Stamp Act. So too did the official delegates from various American colonial assemblies, meeting in Congress at New York to protest against the application of Britain's new statute against the English colonists in America. They pointed out that those Englishmen in American colonies are entitled to all the inherent rights and privileges of those other Englishmen born within the Kingdom of Great Britain. The delegates of the American colonies had assembled rightly in accordance with laws enabling this, laws which had been enacted many decades earlier precisely in England. They themselves had never had seats in England's Parliament, which met in London. Yet, even while meeting as a Congress in America, they still regarded themselves as Englishmen. Indeed, they explained, it is inseparably essential to the freedom of a people and the undoubted right of Englishmen that no taxes be imposed on them but with their own consent, given personally or by their representatives. The people of these colonies are not, and from their local circumstances cannot be, represented in the House of Commons in Great Britain. The only representatives of the people of these colonies are persons chosen therein by themselves. No taxes ever have been or can be constitutionally imposed on them but by their respective legislatures. Now this is the paragraph we're working to. Continued the American objection. It is unreasonable and inconsistent with the principles of the spirit of the British Constitution for the people of Great Britain, through their Parliament in London, to grant to His Majesty, the King of England, the property of the colonists in North America, the late English Stamp Acts, by imposing taxes on the inhabitants of these colonies, and by extending the jurisdiction of the courts of admiralty beyond its ancient limits, have a manifest tendency to subvert the rights and liberties of the colonies. Now, we were talking about this, I think I mentioned it in one of the other videos, in one of my little notes, that, and I'm not sure if I have that document up here or not. I don't see it. That's really what was happening. Remember, under the English common law, before the Constitution of 1787, the Admiralty Maritime Law, which is based on contract, okay, The common law and the law of God is automatic, just by the nature of us being born on earth. That law is automatically imposed upon all of human mankind. But civil law, regardless of what form it takes, this commercial law, Admiralty Maritime, the UCC, this is all done by consent through contract. And this is why Jefferson in the Declaration of Independence wrote that all governments, and he's referring to civil governments now, not God's government. God's law applies to all of us automatically. But civil governments get their power from the consent of the governed. Now, how do we do that? We contract with it. Now, originally, we had very few contracts with the government. Our ancestors back, early in the American experiment, we had very few contracts, but they were part of a social compact called the state constitution and the federal constitution. Now, again, the federal government originally didn't have anything to do with the common law lodial freeman. Not really, unless he was a commercial man, like doing commercial business in New York or Boston or something like that. But the average American was an allodial freeholder living on a farm outside of a city somewhere. So he wasn't really engaged in commerce. He might be a customer of commerce where he goes into town and buys some things within the stream of commerce with gold and silver coin, but then it's a private common law transaction, even though we call it a commercial, a public sale of some sort. It was really a private sale. That was private business, just done in a public way through, a public business. But then commerce started to come on land gradually over some time, and I can kind of show some of that. I may do that in the next video. I kind of want to keep these kind of short. I don't want to go too long anymore. But let me see if I can find some more on this. Oh, let's go to this here real quick. So kind of talking about God's law. Let me see if I can find, there's a good one. Right here, we'll start with this one right here where I'm highlighting. It says the laws of nature and nature's God, a phrase used in the U.S. Declaration of Independence, 1776. But the concepts embodied in the phrase didn't originate with Thomas Jefferson, the author of the Declaration. The law of nature was a common term used by historic legals, must have left out a word there, historic legal jurists such as Grotius, Burlamaqui, Blackstone, and others. The law of nature's God, a lesser used term, was more commonly called the divine will, or the revealed law, meaning the laws of God revealed in verbal form, or the laws of God revealed in the Bible. And that comes from the LONANG Institute, and LONANG stands for the Law of Nature and Nature's God. So if we go up here a little further, we'll get some other sources here. This is from Bouvier's Institutes. The law of nature and nature's, or natural law, is the divine will. And we saw in that other document that God put that in Adam and Eve's, wrote it into their consciousness, into their heart, into their being, so they would know that divine will. And that's how we determine that as being expressly right or wrong when we feel that in our consciousness. Right? If I do something wrong, that I've violated the natural law of God, I will get a pang. If I'm haven't completely given myself over to sin or unrighteousness or unlawfulness, then I will feel some sort of pang, that prick of consciousness. Ooh, I don't think I should have done that. And that is what we call that right reason, the dictate of right reason, where we determine through our reason and logic from what our consciousness is telling us when we violate that law naturally within ourselves. And we don't need a sovereign power outside ourselves to then correct we can repent and then make it right. If we injured someone else, we would go to them and try to make it right according to what the law dictates. The law of God, that is. So the law of nature or natural law is the divine will or the dictate of right reason, showing the moral deformity or moral necessity that there is in any act, according to its suitableness or unsuitableness to the reasonable nature. So again, we will know if morally we've done something wrong, or we know that we've done something right through the reasoning and logic that God gave us as well as our Creator. Sometimes used as the law of human reason. Again, that's an aspect of it. We have to be able to reason through what God has written on our conscience to know right from wrong. And then it goes on to say, in contradistinction to the revealed law. So again, human reason, the revealed law is what God's given us, what we now call, it was revealed to men long before it was written down or codified by Moses at the mountain. It was put in and taught to people like Abraham. It's said in the Bible that Abraham kept all the laws of God. Well, how did he know? How did he know to keep those laws? Because they weren't written down yet. Well, God taught him to him. They were written into him. So that's the revealed law to us, and then we use our human reason to determine when we are correctly keeping the revealed law. And of course, then it was codified when this melting pot of people coming out of Egypt, not just Israelites, but it says there's a mixed multitude, Canaanites and Jebusites and probably who knows who, whatever people that had gone to Egypt because of a kind of a very large regional famine, needed that government assistance because they didn't prepare. Okay, and then it says, in respect to the ground of the authority of law, it is divided as natural law or the law of nature or of God and positive law. So again, there's just those two sources. We've got, they're kind of using several phrases here to refer to the one source, natural law, the law of nature or of God, and positive law. And then it says positive law is the law actually ordained or established under human sanctions as distinguished from the law of nature or natural law, which comprises those consideration of justice, right, and universal expediency that are announced by the voice of reason or of revelation. So we can see that those are the two sources. And now within, God's law is immutable. It doesn't change. We don't have to worry about it. We can't monkey with it. It is what it is. We just learn it, do it, and keep it. And that was the origin of our common law. And then over time, common law became what was known as custom and usage. And then it became known as, let me see if I can find another one here. Yeah, here we go. Okay. Common law became what became known as the rules from the courts, And that kind of happened after the Norman conquest for us Anglo-Saxon administration countries like the United States, Canada, Great Britain, South Africa, Australia, New Zealand, etc. The civil law system is based on statutes. Very little attention is paid to precedents. Okay, and this is why we call that the ruling of our judges as our common law or case precedent. Now remember, the judges weren't always these agents of the king. Okay, what started off as our original common law courts was the jury of 12. This was like in the Anglo-Saxon would be the witan, the white hairs, and that goes back to the Bible. We see a pattern that Moses handed down for judges. It followed a pattern of tens, hundreds, and thousands. So it was actually Moses' father-in-law who said, look, dude, you can't be the judge to all these millions of people when they have a dispute. You need to let those people choose amongst themselves who they feel is the best one, who knows this law, who kind of does it, knows it. Let those be their initial judges and to resolve matters. So we see this pattern of tens, hundreds, and thousands form. And then we see an appellate, and that's kind of an appellate system. We see the cities of refuge and things like that come into play. So it's creating this whole societal law, this juristic society or nation called Israel. And then Israel was scattered all over the earth, and they kind of lost their identity. But they carried with them wherever they went, even though they didn't call themselves Israelites anymore, especially the northern kingdom after the Civil War between the kingdom of Judah in the south and the kingdom of Israel to the north. They scattered and went into captivity by the Assyrians, and then took this law with them all over the place. So that's why we call it this common law, but we'll see a subtle change here around the 1066 AD mark. The civil law system is based on statutes. Very little attention is paid to precedents. The common law system originated in England. The word common, dating from the time when the customs from which the English law later developed became common to all parts of England. In a narrower sense, the term common law is used to distinguish the rules which have originated with the courts, sometimes called unwritten law, from those which have originated with legislative bodies, i.e., written or statutory law. In a still narrower sense, the term common law is used to distinguish the rules which have originated in courts of common law from those which have originated in courts of equity. And that comes from George L. Clark's Summary of American Law. And I've showed you that book before. It's over here on the shelf. Okay, so let's see. This one's from Black's Law Dictionary. Common law as distinguished from law created by the enactment of legislatures. The common law comprises the body of those principles and rules of action relating to the government and security of persons and property, which derive their authority solely from usages and customs of immemorial antiquity, or from the judgments and decrees of the courts. You see there? So there we have the two sources of common law, immemorial antiquity, going back to Mount Sinai, or from the judgments and decrees of the courts, recognizing, affirming, and enforcing such usages and customs. And in this sense, particularly the ancient unwritten law of England. The common law is all statutory and case law background of England and the American colonies before the American Revolution. Common law consists of those principles, usages, and rules of action applicable to government and security of persons and property which do not rest for their authority upon the express and positive declaration of the will of the legislature. Okay. Yeah, let's see what else do I have here real quick. Oh yeah, let's do, oops, I don't want to do that one just yet. Let's do this one. This is from another book I have on the shelf somewhere. This is taken from a book called The Enterprise of Law, Justice Without the State. Page 2, Bruce L. Benson is the author. And he says, using economic theory then, it can be convincingly demonstrated that private sector, i.e. market or voluntary institutions, are capable of establishing strong incentives that lead to effective lawmaking and law enforcement. The resulting legal constraints facilitate interaction and support social order by inducing cooperation and reducing violent confrontation. In other words, what he's saying there is, our natural tendency is to want to get along with people. And it's easier for us to make voluntary agreements with people and keep those agreements than it is to use force and violence. And in fact, our modern reliance on civil government to make civil law, statutory law as we read earlier, and establish order is not the historical norm. And then I added this little, just so that we can kind of keep some terms here that a lot of people just don't kind of understand biblically. The Bible, it's been twisted by men to be used as a tool rather than a law book. You got to get back to the original meanings of things if you're going to understand what the Bible is really telling you. So the Hebrew word rigma is translated counsel, but literally means a heap of stones, i.e. an altar, or gathering of stones. It is from the Hebrew word regem, meaning friend, and is the same three letters of ragam define stone. So gatherings of stones or living stone altars, i.e. men, and typically stone, you'll see metaphors in the Bible for clay, soft clay, malleable clay in the potter's hands. Well, that's a young man, right? When we age, pressure and time of living life makes us harder, turns us into stones. So most of our common law juries way back in the day were white hairs, the elders of our community. They came together for many different reasons in service to the people. Ministerial services, health, education, welfare, judicial services. They were people's courts administering unwritten law. Now we can go to that book that I mentioned, that I read from before. Let's find that one real quick. George Clark, yeah. Okay. So this is that same book, Summary of American Law, George L. Clark, Nature and Sources of Law. It says, before the Norman conquest of England in 1066 AD, justice was administered in England chiefly in people's courts, and the law enforced was in the strictest sense unwritten. That is, it was handed down by oral tradition. After the conquest, the king gradually established a system of royal or king's courts, which eventually all but crowded out the Anglo-Saxon people's courts. The theory of the king's courts was that the king was the fountainhead of justice, and judges acted as his agents. Purely traditionary law, being administered by the people themselves, does not need to be justified to the people, but the civil law as administered by judges, who are set over the people, God's many, must thus be justified. The civil judge must give his reason or basis for his decision, and that's why a judge will write an opinion, whether a concurring opinion or a dissenting opinion if it's a court of more than one judge. So again, that's that same Hebrew rigma. So before, the people were the judges, and then when we started accepting these contracting into these civil systems by our consent, then we started getting these other judges over us. And we see this in the scriptures too. There's 1 Samuel chapter 8 tells the story of how Samuel, who was a good judge in Israel, an elder and servant that obeyed the law of God, as he got old, his two sons replaced him as judges, but they weren't in the same character as Samuel, and they started taking bribes and perverting justice. And then that's when the people cried out for a king. Instead of the people taking matters in their own hands and fulfilling their own duties to remove those two boys from their offices of judgeship and installing new judges that would have been righteous, they instead decided, oh, screw it, we're apathetic, we're prosperous now, we don't want to do this. Let's just get a king to rule over us. So I would suggest you read 1 Samuel chapter 8 in the Bible. Very, very telling. Read it slow because it's exactly what everybody's complaining about today. And that's because we've contracted and asked for a king, a civil law ruling authority, a God to rule over us, whatever form that takes, whether it's monarchy, oligarchy, democracy, whatever. And that's what's happened. Remember, this form of law, this unwritten law of God, it applies to all of us automatically. The maritime law, civil law, statutory law, the Uniform Commercial Code, all of this man-made law, martial law, whatever, you have to contract into it. Now, your contract, your consent, doesn't have to necessarily be an express contract, one that's written down. Most of them are. There's a lot of those. Your credit card agreement, mortgages, insurance policies, driver's license, Now, the terms and conditions are generally the statutes. You've just applied for the license or permit that brings you into the jurisdiction of that specific statutory or commercial law subject matter, like the motor vehicle code. Well, motor vehicles code doesn't apply to me. I don't have a driver's license. Now, that doesn't mean that I'm, don't obey those laws. If I don't want to get run over, I'm certainly not going to walk out in front of a red light when there's cars coming. I'm going to get hit. So, but there's no contract there for me. I'm not obliged to do all that. Now, there are principles in the Bible that say, look, when in Rome kind of thing, obey those kind of rules. If they're not in conflict, here's the important part, if there's no conflict of law. Because if there's a conflict of law, God's law has to be supreme. And then you don't want to keep that man's law. Okay? And the best way to do that is not to contract into that or consent to participate in it. Because the minute I start doing things too, it's not necessarily by contract, express contract. If I start participating in that activity, if it looks like a duck, walks like a duck, talks like a duck, it must be a duck. So I want to be careful of what I do and what you do. If you want to remove yourself from doing those things that give the government a lot of power, you got to be careful what you choose to do. The civil law arose from the ashes of the old Roman Empire and added to its emperor worship the cloak of nominal Christianity. So now we see this blending. From the 10th century, the imperial Roman Church had become the chief carrier of the old Roman Empire's civil law tradition. The visible trappings and ceremony of its religious political doctrines through deceit lent an air of intimidation, respectability, and prestige. Thus, by the canon law, ancient Rome's civil law persisted, not only in its continental presence on the European mainland, but also by its tentacles reaching, groping, grasping throughout the world. By the 7th century, Roman law again reached into Britain, this time, however, not by Rome's legions, but by Rome's priesthood. Thus began the earnest struggle between the common law and the civil law, between the scriptures and Justinian's code. That struggle came to dominate, define, and determine the history of Britain, her colonies, North America, and the United States. And that's taken from Brent Winter's book, The Excellence of the Common Law, Compared and Contrasted with Civil Law in Light of History, Nature, and Scripture. From page 38, that's that book right there. If we search out the origins of Roman law, we must study Babylon. Whoa, what? That's from Pollock and Maitland, The History of the English Law Before the Time of Edward I, on page 561. So this is important because this Roman law that we're talking about up here came from Babylon. And this is a very interesting little ditty here on the side note. And I'll end on this because we're kind of running long, and I kind of want to keep these as close to half an hour as possible. But when Persia invaded Babylon and took the city, the priests of the Babylonian mystery religion escaped with all of their, documents and records and accoutrement, their, little icons and pageantry and all that stuff. And they escaped out of there and weren't captured. And they took refuge in Pergamos. And that should be, if you've read the New Testament, Pergamos is important, especially in the book of Revelation when Christ is talking about the 7 churches. Pergamos is one of those. And he says something about this is where Satan's seat is. What he's referring to is this Babylonian law. Because that Babylonian form of mystery religion and law and commerce and mercantilism went from Babylon to Pergamos. And they carried with them this title of Pontifex Maximus, or the bridge builder. And that title was picked up by the kings of Pergamos, and the last king of Pergamos, Attalus III, I believe, if I remember correctly, he made a deal with the Roman king. For the Roman king, he said, look, I don't have much longer to live. I'll be a vassal to you. And when I die, you will inherit everything that I have, including all my titles including Pontifex Maximus. And that's how this Babylonian law then made its way to Roman law, was through this Babylonian mystery religion, the title of Pontifex Maximus, and all of those customs and traditions from Babylon, not from Mount Sinai, not from Abraham, not from Noah, not, from Nimrod. Okay? So we can see these two flows of law all through history. And and remember, the form of law that is automatic to all of us is the one most people hate. But it's the one where all of your rights are, where all of your freedom is, where absolute freedom and liberty resides, is in that very limited law of what the Jews call the Torah, the 5 books of Moses, from Genesis to Deuteronomy. And that's where we're going to get the bulk of that law from. And most of it is restatements. Like the whole book of Deuteronomy is basically a restatement of the law. And that's basically what the Sermon on the Mount is. And through several of Christ is teaching from that law. So many of the things that Christ said in red letter versions of the Bible, if you had a black letter version, which gives you the citation he's giving from the Old Testament out of, Exodus, Numbers, Leviticus, Deuteronomy, so on and so forth, you'd go, whoa, how many times is he? And that even for the apostles like Paul and Peter and all of them, they're quoting the Torah over and over and over again. So let me just make sure that there's nothing else I want to definitely hit with that today. Got that one. Got that one. Let's see what else I had up here. Oh, yeah, maybe we'll do that real quick. This will be interesting. There was a case before the Ninth Circuit, I believe, Nordyke versus King. And unfortunately, I don't think I included a citation here, but this is from Nordyke versus King. I believe it was in 2008. And this, I believe, is the, like I said, the Ninth Circuit, if I remember right. And this has some very interesting things in it. We are similarly barred from considering incorporation through the Privileges or Immunities Clause. And they're talking about the 14th Amendment there. That federal citizenship is also one of your big nexuses that causes you a lot of problems. Okay, but that's the last thing you want to change. Okay. We are similarly barred from considering incorporation through the Privileges or Immunities Clause. Now, this is talking about a gun case, okay? The clause provides that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. All right? Privileges and immunities. Are those common law, natural law rights? No. They're created civil law privileges and immunities under the 14th Amendment. Section 1. Okay. This language protects only those rights that derive from United States citizenship. Ooh, civil rights. And there's 2 ways of looking at civil rights, and they're going to kind of touch on that here. But not those general civil rights. And I put a little note here, which are called unalienable, not able to be sold, traded, or given away, e.g. life, liberty, etc., and inalienable, which are able to be sold, traded, or given away by consent, such as speech, due process, habeas, arms, etc. Okay, so, but not those general civil rights independent of the republic's existence, right? These came from God. These are what we call unalienable and inalienable, common law rights, natural law rights, whatever you want to call them, independent of the republic's existence. So no matter what, just by the nature of being human, the law of God puts these rights upon you because that law is automatic on you. Okay, the former include only rights the federal Constitution grants. So they come from that document. The document itself isn't recognizing pre-existing rights. In other words, that's a regulated and licensed privilege. Privileges and immunities. Oop. Or the national government enables, grants and enables. But not those pre-existing rights. The Bill of Rights merely protects from federal invasion. The Second Amendment protects a right that predates the Constitution. Therefore, the Constitution did not grant it. That's why it's an inalienable right. It's not unalienable. You can contract away your right to keep and bear arms. And that's what most people have done for a privilege and immunity under license through registration. And the fact that, remember, if you watch the very first few videos of this, you don't really own that gun. You discharged it. You didn't pay for it in common law. You discharged that debt within equity and commercial law. So you can't really own it outright. All right? It has always been widely understood that the Second Amendment, like the First and Fourth Amendments, codified a pre-existing right. It necessarily follows that the Privileges or Immunities Clause of the 14th Amendment did not protect the right to keep and bear arms because it was not a right of citizens of the United States. Ooh, ouch. I'm going to read that last part again. It necessarily follows that the Privileges or Immunities Clause of the 14th Amendment did not protect the right to keep and bear arms because it was not a right of the citizens of the United States. Okay, you got to be keeping common law in order to exercise that right. You got to now. I don't know how you're going to do that unless you manufacture the gun yourself outside the stream of commerce, or you privately contract under common law rules to have a gun made intrastate, not interstate, by a competent gunsmith. There's a couple of different ways you could do that. I'm not going to go into details here, so don't get any stupid ideas if you don't know what I'm talking about and rush out and do that and get yourself thumped in the head. So I put this up here because this kind of shows you the effects, just like they were talking about in that first document I showed you about, this whole thing of the courts of admiralty. All of these civil law courts are operating on consent through contracts. Now, we don't always call them contracts, and it's not necessary. We don't always call this admiralty. Okay, a better general phrase would be statutory civil law, but that includes admiralty maritime, that includes the UCC, that includes all those statutory laws. Every one of those things you are contracting yourself into: marriage licenses, driver's licenses, all the social security numbers. These are all forms of basically what used to be called seaman's papers to go on a ship to do the real admiralty law out at sea. In commerce, you had to have your seaman's papers to get on a ship, to be an employee on a ship. Well, now all of these things, even though we don't call them seaman's papers, they kind of behave like seaman's papers. Wedding, marriage licenses, driver's licenses, social security numbers. All these contracts that you do, they kind of act as your seaman papers, pulling you into that form of law and binding you up. And that's the best way to usurp. I don't want to say usurp the Constitution, but if I were a king or a government and I wanted more control over somebody, just as they wrote in the Declaration of Independence, all governments get its consent or power from the consent of the governed. Well, if I want to increase that power, I need to get more people to consent and extend offers. So if I want to do something that's constitutional, but kind of eludes the Constitution, so that I can get you to do what I want you to do as your ruler, I got to do that through your consent via contract. And that's why the Constitution has a clause, and this goes back into time immemorial. A free man has, everybody, even a man or a person, a legal fiction, has a right to contract, and the Constitution ensures that. At Article 1, Section 10, no state shall, ... make any law impairing the obligations of contracts. And two persons can contract, a man and a person can contract, a natural person and an artificial person. You can contract with the government. That's what Social Security is. Now, we don't call everything just like maritime law. We don't call it all maritime law, even though all this law behaves the same way. And you're going to see fringed flags and all the accoutrements of maritime law everywhere. But that's all, representing that statutory commercial law from the state. Okay? And you've contracted into all that. So again, you have to undo those contracts, but you have to do that righteously and legally and lawfully so that you don't get thumped. And the best way of thinking about this is the Apostle Paul said, I can't remember exactly where, if you do a search on an online Bible, you'd be able to find it. Are you called being a servant? Care not for it. If you can be free, choose it rather. In other words, this journey, if you want to come out of this Babylonian nightmare, coming out of Babylon, hey, my people, come out of her. Come on, come out of her. Do it in baby steps. Find these contracts that you can undo, that are easy to undo, that aren't going to affect your life too much and make too many dramatic changes for you. And then you can start making arrangements and changing your life so that the next round of contracts that you can undo don't make a huge splash in your life and cause you pain and suffering. That's what the Apostle Paul is talking about. Are you called being a bondservant? Care not for it. If you can be free, choose it rather. And what I would add is when you can be free. So make the corrections that you need to do to start removing yourselves from these contracts. As we go along with this playlist, we'll talk more and more about that. I appreciate you watching. Remember, as all the disclaimer, I'm not a professional YouTuber. I hope to get better at this. Bear with me. It's more for educational purposes. Hopefully this is because you're watching this because you don't like the direction things are going and you don't understand why. And you're just trying to figure out why you're getting thumped so hard. Hopefully this will help to answer some of those questions if you watch this playlist. Remember, this isn't legal advice. This is for educational purposes only. Thank you very much for watching. Click that subscribe button and the bell icon if you like to get updates when I upload a new video in this series. Thank you very much. Bye-bye.